Talk about Unit 39, Property Management and Planned Communities. So we're talking about management of residential or commercial rental properties require a special skill set. Managers must be able to market themselves to clients, market properties, evaluate tenants, prepare complicated leases, account for monies, maintain properties, evict tenants, and much more. This unit discusses many of these issues. In addition, this unit discusses planned communities and the disclosure requirements when properties in these communities are resold. So we're going to go over the following topics: property managers' duties, requirements and options for property management agreements, property management record keeping, finder's fees, illegal property management, planned communities. And after completing this unit, you're going to be able to define the parties to a property management agreement, list the duties a property manager has to their clients, list the statutory requirements for property management agreements, list options that may be included in property management agreements, discuss requirements for trust accounts, recite the requirements for keeping property management records, explain when finder fees may be paid to unlicensed tenants, discuss illegal property management situations, define a planned community, list the items that must be disclosed when reselling a property in a planned community. Okay, so you're going to need to do some independent studying. Okay, so I'm going to go summary for Unit 39. The parties to a property management agreement are the owner and the broker. Owner and the broker. Under a property management agreement, the broker is the general agent of the owner. Property managers have fiduciary duties to clients, right? Fiduciary duties include carload, right? Care, responsibility, loyalty, obligation, disclosure. This is carload. Property manager duties include gathering market data about rental rates, marketing, leasing, evicting tenants, hiring and vetting employees, maintaining properties, accounting, record keeping, and much more. Under Arizona law, property management agreements must state all materials, terms, and conditions of the property management firm's services, obligations, duties, and responsibilities to the property owner, be signed by the property owner or his agent and the property management firm designated broker, specify a beginning and ending date, contain cancellation provisions that are agreeable to both parties, provide for the manner of disposition of all monies collected by the property management firm, specify the type and frequency of status reports to the owner, state the amount and purpose of monies the property management firm holds as an operating reserve for emergencies and other purposes, provide for the disposition and allocation of interest earned on trust account monies, state the terms and conditions of compensation the property owner pays for services pursuant to the property management agreement, not be assigned to another licensee or licensed entity without the express written consent of the property owner. Under Arizona law, property management agreements may provide for automatic renewal with at least 30 days prior written notice to the client, call for liquidated damages or cancellation fees for early termination, allow for licensed or unlicensed signatories, and require dual signatures on checks. All property management accounts must be trust accounts. Property owners may not be a signatory on a trust account. The broker may not be a signatory on a property owner's personal account. In residential property management, leases and finder fee records must be kept for 1 year. Financial records must be kept for 3 years. Commercial property management records must be kept for 5 years. When a property management agreement is terminated, the firm must give the owner an accounting within 5 days, a list of all security deposits. 35 days is reimbursement of all monies in property management account. 75 days is the final accounts receivable and payable list. Another 75 days is the final bank account reconciliation. Finder fees may be paid to unlicensed tenants in an apartment complex. Finder fees must be either a rent credit or rent reduction and may not be paid in cash. Illegal property management activities include real estate salespersons or associate brokers acting as a property manager on their own outside of the brokerage company. So again, if you're acting outside the company and you're doing property management, it's an illegal activity because your broker has to be wanting to do property management in order for you to do that. Unlicensed persons providing property management services. A planned community as defined in Arizona law is a development which includes real estate owned by the HOA, created for the purpose of managing, maintaining, or improving the property, and in which the property owners are mandatory members and must pay HOA assessments. Within 10 days, a receipt of written notice of a pending sale, the purchaser must be provided with the following: copy of the bylaws and association rules, copy of the planned community declaration, name of the principal contact of the association, account of association assessments, statement as to whether a portion of the unit is covered by insurance paid by the association, total amount of money held as reserves, a copy of the current operating budget and most recent annual financial report of the association, whether there are any alterations or improvements to the unit which violate the community declaration, information regarding litigation pending against the unit owner by the association or against the association by the unit owner. So that's within 10 days of receipt of a written notice of a pending sale, the purchaser must be provided with the following. So that's when the purchaser has to be provided with this. In the community is less than 50 units. The seller must provide the information. If it's 50 units or more, the association must provide the information. So where I'm at right now, Carter Ranch Community, there's 50 units or more. There's like 100 some units in the, and so the HOA has to give the bylaws and the association rules. But if you live in a community where less than 50 units, the seller must provide the information. So whoever you're buying it from, so it depends on how many units you have in your community. The board of directors of the association must meet at least annually and comply with open meeting law requirements. Number 1, when a broker acting as a property manager receives monies, the funds must be deposited within how many banking days? Charlie C, 3. So you got 3 banking days. So when a broker acting as a property manager receives monies, the funds must be deposited within the banking days. You got 3 days to deposit the banking days. So 1 year, 2 years, or 4 years. So 1, 2, or 4? No, it's 3. A couple sells a property through a short sale, and the HOA dues have not been paid for over a year. Who is legally responsible to pay them? Bravo, the seller. Seller. So the seller is, so a couple sells a property through a short sale, right? What's a short sale? A short sale is you owe more money to the bank than it's worth, right? So short sale is, you owe because you would just sell it, right? If it was valued at more money than you owe. But if it's a short sale, you owe more money. So a couple sells a property through a short sale, and the HOA dues have not been paid for over a year. Who is legally responsible to pay them? So the seller. So a couple sells a property through a short sale, and the HOA dues have not been paid for over a year. Who is legally responsible to pay them? So if the seller still owns the property, they're responsible to pay those HOA dues. So as a lender, no. Homeowners association, no. The broker, no. A property manager's duties include all the following items except what? Except Bravo, accepting personal liability for losses. Property manager's duties include all the following items except accepting personal liability for losses. So a property manager's duties, they don't they don't have to accept personal liability for losses. But what are they responsible for then? Well, collecting rent, right? That's one thing a property manager has to do: collect rent, prepare financial reports for the owner, yeah, and market the property. Yes, that's another one. So they collect the rent, they market the property, they prepare financial reports for the owner, but they don't accept personal liability for losses. A property management agreement for a large apartment complex must contain provisions for all of the following items except what? So this would be alpha, except the operating budget. So a property management agreement for a large apartment complex must contain provisions for all the following items except the operating budget. So is it for status reports to the owner? No. Disposition of money collected by the licensee? No. The amount to be set aside for repairs? No. So again, the answer is alpha. The operating budget. A property management agreement for a large apartment complex must contain provisions for all the following items except the operating budget. So they need to have provisions for status reports, yeah. Disposition of money collected by the licensee, yeah. The amount to be set aside for repairs, yeah. But they don't need provisions on the operating budget. What should a property manager do when the building is 100% occupied? So this one's C. They should consider raising rents. Consider raising rents. So what should a property manager do when the building is 100% occupied? Well, they should consider raising rents. Should they request a raise? No. Consider cutting back on amenities? No. Increase market efforts for new tenants? No. They should consider raising rents. Number 6, which of the following would a property manager not be responsible to report to the property owner? So, which of the following would a property manager not be responsible to report to the property manager? Would be delta, the market value of the owner's property. So it would be D, the market value of the owner's property. So which of the following would a property manager not be responsible to report to the property owner? So the market value. So property manager doesn't have to report the market value, right, of the owner's property. Right, the market value of the owner's property. That's something that the property manager does not have to report to the property owner. The market value, right? They don't have to do a comparable market analysis, CMA. They don't have to tell them how much value the owner's property is, but they do have to report the rental funds, the rents of comparable property and area, the information on preventative maintenance. Those are things they have to. Which statement regarding a broker's trust account is incorrect? So this is C, Charlie. They must be reconciled annually. They must be reconciled annually. Which statement regarding a broker's trust account is incorrect? So they must be reconciled annually. That's not true, right? They have to be reconciled before annually. It says A, it may be titled as a fiduciary account. Yes, because when you open up a property manager's account, that account is a fiduciary account. And in that fiduciary account, you would typically put the name of the person on there. B, monies must be deposited within 3 banking days of receipt. That's true. Licensees or unlicensed employees of the brokerage may sign on the account. That's true. A real estate agent working for a broker is managing property for a client without the broker's knowledge. Which of the following statements is correct? So this is Bravo B. All property management activities must run through the brokerage. All property management activities must run through the brokerage. So that statement is correct. So real estate agent working for a broker is managing property for a client without the broker's knowledge. So all property management activities must run through the broker. So if you're running it and you don't have the broker's knowledge, then you are operating illegally. So there's some agents out there, including myself, back in the day, we thought we could do property manager. They don't really tell you up front, but if you want to do property management, one, your broker has to be okay with it and has to probably practice property management. And you probably need a broker's license. So A says the licensee is in compliance if managing only one property. No. The licensee is in compliance if the license is an associate broker. No. The licensee is in compliance if the property owner is a corporation. No. Number 9, the main objective of a property manager should be to provide the owner with what? Alpha, the highest net return on the amount of capital invested. So as a property manager, your main objective is to provide the highest net return on the amount of capital invested. And I would say to the owner, right? So as a property manager, you want to give them the highest amount to the owner. Be the highest gross return? No, it's the highest net. Complete monthly reports of the building and tenants? No. Increase income based upon the adjustment of rent scheduled to current or change conditions? No. Which of the following is not true regarding a property management trust account? So this is Delta. Only licensed signatories are permitted. Only licensed signatures are permitted. That's not true. So which of the following is not true regarding a property management trust account? Only licensed signatures are permitted. It's not true. Multiple properties can be in one trust account? Yes. A salesperson can be a signatory on the trust account? Yes. If authorized, a salesperson may sign checks paying miscellaneous maintenance fees? Yes. Only licensed signatories are permitted? No. A property manager wants to show rental property to a prospective buyer, but the tenant doesn't know that the property is for sale and refuses entry to the property manager. The property manager must, bravo, provide the tenant with reasonable notice of entry. Provide the tenant with reasonable notice of entry. So that's what the property manager must do. So it says, again, a property manager wants to show rental property to a prospective buyer, but the tenant doesn't know that the property is for sale and refuses entry to the property manager. So that property manager must provide the tenant with reasonable notice of entry. So, I mean, you can give them a week, 2 weeks, 30 days, let them know, hey, there's a prospective buyer that's going to come through here so they can open up and show the property. So A says, show the property according to the prospective buyer's schedule. No, it doesn't have to fit their schedule. Just have to give them reasonable notice. C, not show the property. No, you can still show the property even if tenants are still living there. D, evict the tenants to make the property available to show the prospect. No, you don't have to evict the tenants to show the prospective buyers the property. When a broker enters into a contract to manage an apartment building, the broker becomes a fiduciary. Fiduciary, so we have carload, CARLOD. Carload, that's care, accommodation, reasonable skill, loyalty, obligation, disclosure. So those 6 things is carload, that's a fiduciary, right? The broker becomes a fiduciary. We have fiduciary responsibilities to take care of our clients. So that's when a broker enters into a contract to manage an apartment building, the broker becomes a fiduciary. So does the broker become a trustee? No. Receiver? No. Director? No. A prospective tenant in a wheelchair wants to rent an apartment. The property manager must, bravo, allow the tenant to build a wheelchair ramp to the unit. So the property manager must allow the tenant to build a wheelchair ramp to the unit. How about A, only show the prospective tenant properties with the wheelchair access? No. Charge the tenant additional deposit to install the ramp? No. Build a wheelchair ramp, but adjust the security deposit according to the building costs? No. Which of the following may a property manager not receive? So this one's Delta rebates from suppliers. So which of the following may a property manager not receive? They may not receive rebates from suppliers. They can't receive any rebates from the suppliers. Can they receive reimbursements for out-of-pocket expenses? Yes. Free rent on an apartment unit? Yes. Monthly management fee? Yes. So, I mean, it's kind of good to be a property manager. You can get free rent on an apartment unit, monthly management fees, reimbursement for out-of-pocket expenses, but they can't get rebates from suppliers. Number 15, a property governed by a homeowner association of 50 or more units, right? So you got 50 or more. So now the association has to provide bylaws. More use has a patio cover which was built in violation of association declaration, CCNRs, prior to the closing. So prior to closing, the association gave notice to the buyer regarding the violation. After the close of escrow, which of the following statements is correct? C, the patio cover is in violation of the association rules, and the buyer can be forced to remove it. So the patio cover is in violation of the association rules, and the buyer can be forced to remove it. The patio cover may remain as is. No. If the association did not inspect the property prior to closing, the patio cover can remain. No. The buyer can hold the association liable for the cost of removal. No. The property manager works for the property owner. So property manager, who do they work for? They work for the property owner. That's sort of straightforward. Property manager, they're going to work for the property owner. Property owner hires property manager. Property manager works for that property owner. Property manager works for the property owner. So does the property manager work for the broker? No. The tenant? No. The lender? No. A property management agreement must contain all the following items except what? Delta, age of the property. So do they have to contain, property management agreement, does it have to contain the description of the property? Yeah. The termination date? Yeah. The beginning and end date of the agreement. The names of the parties? Yes. The age of the property? No, does not need to have the age. Which would be considered illegal property management activities? So this one's C, a licensed associate broker managing property directly for an investor. So that would be illegal property management activities. So a licensed associate broker, right? So when you have a licensed associate broker managing property directly for an investor. So a licensed associate broker managing property directly for an investor, that's an illegal property management activity. So how about a firm specializing in commercial sales offering residential property management services? That's fine. A licensed salesperson entering into property management agreement on behalf of her broker? That's fine. A non-licensed manager of a 250 unit apartment building who receives a salary plus an apartment as compensation. That's fine too. The fact that they're unlicensed, that's okay because they're only doing it for what? For one place. You don't have to be licensed. As long as you're taking care of property, you don't have to be licensed, but as long as you can only manage one property. And does it matter if it's 250 units? No, it doesn't matter. A broker who does property management is a general agent. A broker who does property management is a general agent. So, a broker who does property management is a general agent. Right? So they're a general agent. A general agent is a broker who does property management. Are they a specific agent? No. Universal agent? No. Managerial agent? No. They're a general agent. Arizona law requires that property management agreements contain all the following provisions except what? Charlie, written registration of prospective tenants. Written registration of prospective tenants. So Arizona law requires that property management agreements contain all the following provisions except written registration of prospective tenants. So that's the one we don't want. You don't have to have a written registration of prospective tenants. I mean, the key word here is prospective tenants. Do you have to have a disposition of all monies collected by licensees? Yeah. Extent of the licensee's authority to order repairs or improvements? Yes. Do you need a frequency of status reports to the client? Yeah. You have like a frequency of status report. 21, if the property management agreement contains an automatic renewal, the broker, what? Must provide the owner with a renewal notice at least a month before the renewal date. So it must provide the owner with a renewal notice at least a month before the renewal date. So if the property management agreement contains an automatic renewal, the broker must provide the owner with a renewal notice at least a month before the renewal date. Does not have to worry about the beginning and end dates contained? No. Is required to clear interest from any trust accounts held on behalf of the owner at the time of the property management agreement's renewal? No. Must reduce the trust account's balance to zero and reopen it when the property management agreement renews? No. Which of the following items is not the responsibility of a property manager? Is the legal counsel. That's not a responsibility of a property manager. They don't have to give you any legal counsel, right? They're not practicing law. So what about management? Yeah. What about marketing? Yeah. What about financial reports? Yeah. Legal counsel? No. So, they'll manage the property, they'll find tenants, they'll market it, put it on Facebook, they'll create these reports and give it to you. An apartment complex has 10 units. 6 units rent for $650 per month. 4 units rent for $475 per month. Over the year, there is a 10% fall out rate, and the property manager receives an additional $175 for every new unit rented. If 4 new units were rented and the manager receives a 5% commission on rents collected, what is the manager owed? So this one's Bravo 3,832. So here you're going to need to do some math to figure out what's the manager owed. 24. All the following statements about property management accounts are true except what? Delta records on broker-owned rental properties are not required to be kept. So I'll find all of these statements about property management accounts are true except what? Records on broker-owned rental properties are not required to be kept. That's not true. So records on broker-owned rental properties are required to be kept. They are required. Financial records must be kept for 3 years. Yes. Brokers do not have to review and initial residential leases. True, brokers do not have to review initial residential leases, right? Commercial leases, yes. Residential, no. Rent paid on broker-owned properties may not be deposited in a property management trust account. True. So rent paid on broker-owned properties may not be deposited in a property management trust account. An investor purchases a regional mall and wishes to have the tenants confirm terms and conditions on their current leases. His property manager should get what from each of the commercial tenants? Delta, an estoppel certificate. Estoppel certificate. So an investor purchases a regional mall and wishes to have the tenants confirm terms and conditions of their current leases. His property manager should get what from each of the commercial tenants? An estoppel certificate. Writ of execution? No. Absorption certificate? No. Concessions? Recapture agreement? No. A property 26. A property management agreement is a contract between the broker and property owner. The broker and the owner, right? So that's the two, people involved in property management. So you got the broker and the owner. Is it the salesperson and the broker? No, the salesperson works for the broker. And they represent, one in each other. They're kind of like the same people. Salesperson is an extension of the broker, right? They represent the broker. They act in the name of the broker. They do everything in the name of the broker. They represent the broker. Salesperson and property owner. Banker and property owner? No. Broker and property owner. All right, next up, we're going to go over Unit 40, which deals with Arizona water law.